Um, this is someone who received a letter that had to be signed back to their current company, amending their original 1994 work contract. They were encouraged to have a lawyer look at the changes. And this person had been with the company for nearly 19 years. And now there was a merger between that company and another one. And the person's position as manager was expected to potentially change in the new company. And they were also told, I'll read this part because this is a little particular, the newly formed company may terminate your employment at any time without cause by providing you the notice of termination or pay in lieu of notice, severance pay, vacation pay, accrual, and benefit coverage continuation required by the Employment Standards Act as amended, along with any other payments or entitlements. This person says, after 18 and a half years of excellent service, is this acceptable? This person was also told that if they didn't sign back the deal on the right time, that they wouldn't be paid. So they're wondering, if they haven't accepted the letter of employment, does that mean their job is gone? And are they terminated? And who would decide what measure my dismissal would fall under as the guidelines, the old company or the new company?
Okay, so a lot going on there.
Yes.
The basis of this is basically the death of someone's severance package, and you have to be really, really careful here. What's happening is if I could just summarize it in plain language,
Sure.
is an individual who does not have an employment agreement is being asked to sign one, and from the looks of his question, he's not just being asked to sign one. He's basically being forced because he says he wouldn't be paid if he doesn't sign the agreement, and that by itself could be a form of duress. But it's not clear to me if it's that he won't be paid his regular salary or if he won't be paid whatever incentive he's being offered to sign that new agreement. So let's kind of unpack all of this. Start from the very beginning. Is an individual who doesn't have a contract like this one is entitled to what we call common law notice of termination or pay in lieu thereof, which is your basic general severance entitlement by default. And that's as good as it can get for people, because that general default severance entitlement is based on what's fair. And what's fair is considering how long this guy works for, what type of job he did, how old he is, and how long it would take him to find a comparable one. So on that basis, he would be entitled to a lot more than he would get under the clause that the employer is trying to insert into the employment agreement. And the clause that's trying to be inserted there essentially says, if I could decode that for you, it says we can terminate you and give you only what the Employment Standards Act says. And the Employment Standards Act has a cap. The cap is that after 8 years, it's a maximum of 8 weeks notice, and it's a maximum of 26 weeks severance pay if you've been there for 26 weeks. So this is considerably less than he would otherwise be entitled to. So the question is why would anyone sign something like this? And I don't have a good answer for why they would, but in most cases that I see, it's because they don't have a choice. So what an employer needs to do is they need to give you something to give you a choice. So when he says here, I'm not going to be paid if I don't sign this contract, it's not clear to me if he's not going to be paid whatever bonus they're offering him to sign it, or if he's not going to be paid his salary. If he's not going to be paid his salary, that's a big deal. That's a form of duress. If he signed this contract and the employer tried to enforce this clause on him, he could argue clearly it's unenforceable because of the duress. So there's a few options here in terms of practical advice. The first thing is that he doesn't have to sign this agreement. Okay, you cannot be physically forced to sign a contract that has that large of an amendment on the terms of your employment. And if he doesn't sign it, the company that he works for could fire him. Okay, and if they did fire him, he would be entitled to his common law severance payment, which is essentially based on how long it would take him to find another job, not on this clause here. Okay, so he's protected in that sense. If he does sign it and he gets something in exchange for making this deal, so he gets some form of an incentive or something he didn't have before, and down the road the employer terminates him as a result of that, they're going to apply this very prejudicial clause here. So
minimum severance.
The minimum severance, right. So
not the one he would have gotten had he...
Not what he would have had otherwise. So basically what the employer's trying to do is they're trying to buy themselves out of a severance obligation, and they better give him something good in exchange for that, because they're certainly curtailing what this guy would be entitled to. So if I were in his shoes, I'd want to make sure that I got a salary increase, a promotion, some form of a signing bonus, something that substantially made up for what I'd potentially be walking away from.
Right, because if they decided to end his job, he'd get the minimum rather than what he would have gotten for 18 plus years of service.
Mm-hmm.
Right. Now, is it fair that can companies do this when there's just a merger? They can just reset your severance, start from zero again?
Well, it doesn't go to zero because the legislation in Canada and provincially and federally deems the purchasing employer the successor for the purposes of employment standards legislation. So you can never contract out of the basic minimums that you would have, and the legislation specifically makes the acquiring company a successor for the purposes of that. But on the common law, which is everything outside of the legislation, you can be contracted out of it, and you just need to be aware of what's happening. I saw a bunch of clients over the past 2 weeks at a company where this type of thing exactly was happening, and in the end, it was problematic because most of those people said, "Geez, I don't like the clause that's in this employment contract. I don't like what it says here. I don't like how the company that's taking over can handle the employment obligations it has towards me. But I would rather have a job and have a bad contract than be out of work, looking for a job and trying to sue someone." And that may or may not work itself out favorably. So unfortunately, the way the current law is set up is employers, in my view, really have an advantage, a negotiating and bargaining advantage when it comes to employment contracts. And the best thing people can do is, number one, is just keep themselves apprised of what it is they're actually being asked to sign. A lot of people just sign things thinking that it's standard, and it's not. Have someone take a look at that, or make sure you do some research so you know what you're being asked to sign. Number two is you need to understand when things are unenforceable or not, because if this gentleman is being told that he won't get his pay unless he signs this contract, well, let's just assume that's his base salary. If they were using that threat over his head to not sign this contract, I may tell him to just sign the contract because they're not going to be able to get away with whatever this clause says down the road. So you have to look at the circumstances as well.
Right. Okay. Now we do have a new question that just came in, so let's see if we can, if it's reasonable to answer it. Let's see. We've got, this is a person who's been with the company for 4 years, never had any marks on their file, and took a transfer to a different location but the same position, and got a warning after 9 months saying they were incompetent, treated very differently by their supervisor, and got picked at, which made this person lose confidence over the next number of months. Under ongoing stress, unable to concentrate, and this person requested to see a doctor but got refused by their supervisor as well as by their manager, and was told to take a competency test, which isn't fairly common, they said, at this company. This person, not she, I'm not sure who it is, this person called an ambulance to transport them to the hospital and advised by the physician that their anxiety and stress levels were very high and this person should see a psychiatrist. Currently, this person is on short-term disability due to acute anxiety disorder, the stress and depression caused from the workplace, and is on treatment. This person feels like they were personally discriminated by their supervisor and manager at this new location and intimidated by what person's boss was a bit of a boot camp management style. And this person asked, what should I be doing next?
There's a lot going on there.
Yes.
Number of different issues that were raised. The question, what I should be doing next, the best answer to that is get healthy, number one.
Yeah.
I wouldn't want to return to a work environment that had that type of situation in it, and I'm sure I wouldn't want to return to an environment where I was asked to take a competency test because I was told that I was incompetent. So there's nothing requiring her or him to go back to work. Okay, and sometimes it's just not worth it, and sometimes that's the best advice. If this individual who has this type of psychological problem wants to consider getting into a lawsuit, they need to know what they're getting into. And sometimes the advice I have to people is it's probably not the best thing for your health. So right. Without going into too much detail, this person's going to have to assess really whether or not it's worth it in terms of whatever legal claims are available. He or she is still on disability, so they're inactively employed, and at the conclusion of their disability period, whenever that is, that the employer has to have a job there for them. And if the employer doesn't, it's a termination. And if this individual wants to go back to work, the employer has to accommodate whatever medical restrictions are there. So she or he should get a doctor's note or medical opinion clearly outlining what types of accommodation are needed to make sure that she or he doesn't have a relapse again. But it may not be, I mean, this to me is a dead-end situation. It's a dead-end scenario. I'm not sure anyone will want to go back to work in that scenario.
Right. So is that the kind of case where you might just cut your losses and...
Seems like it.
Would you just resign?
You could, but not right now. I mean, the individual's on disability, and presumably is being paid by the insurance company.
Right.
So you wouldn't want to cut that. You wouldn't want to sever your employment ties because during your period of inactive employment, you're receiving some form of compensation. What I would recommend is to wait until you're healthy enough to return to work. And if you're not prepared to return to this particular workplace, yeah, you may want to resign. Or if you are prepared to go back and deal with it, there are various steps you can take to try to ameliorate the conditions of the workplace. But it sounds like we're talking with someone with a very thin skull to begin with, and I just don't see it working in the end.
Right. Now, in that kind of a case, does that require you sort of talking to HR, seeing what you might be able to work out, finding maybe a new role, or going back to your old position, or some other avenue that doesn't require sort of a legal avenue or a confrontational one?
Yeah, if you're gonna go back, you better be clear with your employer in advance of what your medical concerns are and what led to the cessation of or what led to the issue that started this problem. So you better be clear about that and make sure that you have an accommodation plan set up. And you certainly could request or demand a transfer away from the boss that caused the problems. There's law about, and it's not clear-cut from me just looking at the question, whether or not the employer would have to resituate this individual in another job there. I mean, there may not be another job to do. If there is another job that's available that's away from this reporting relationship, there may be an obligation to place the person there.
Right.